Hey everyone, welcome back to an all-new episode of CourtRoom Quarterback, the experiences and thoughts of a court-martial defense attorney with attorney Joseph L. Jordan, the founder of the Jordan UCMJ Law Group. I am your host, Mike Leon. You know, Joseph here is a former Army JAG and worldwide court-martial defense attorney who's tried more than 240 court-martials to verdict, and he's handled more than 350 military cases, not only here in the U.S., but all across Europe, the Pacific, and in the Middle East. And in today's episode, this is part 2 of our series here talking about cross-examination. We're going to focus on purpose and preparation in addition to adaptation, like how cross-examination changes depending upon who's in that witness chair and what happens when things don't go according to plan. You know, Joseph, it's good to see you as always. And continuing with this cross-examination theme, not every witness obviously can be crossed in the same exact way. So when you do see who's in that witness chair, what are you kind of assessing first before you start the questioning?
Sure. The assessment starts before you get in the courtroom. You know who the government's witnesses are. So it comes down to homework, number one. Number two, you're assessing who the person is, their experience in life, their age. You know, you cross a child differently than you cross an adult. What are they bringing to the table? Are they an expert? Are they a fact witness? Are they the accuser? So those are the things that you look at because that dictates the tone, pace, and subject matter of your cross-examination.
Yeah. Well, let's piggyback on what you just said about the child part of this, because obviously there's a clear difference between having an adult in that chair versus a child. Like, how does the tone and structure kind of shift for you?
So first of all, you want to be empathetic. It helps to be a parent, which I am. So you understand how to talk to children, number one. Number two, you want to acknowledge the foreign nature of the situation that those children find themselves in. It's highly unusual to sit in a box, staring at a bunch of adults, asking, and answering relatively difficult questions in front of a bunch of strangers with somebody else sitting higher than you, staring at you as well, that being the judge. So you just acknowledge, be empathetic, and if oftentimes I have the opportunity to interview the child beforehand, for tactical reasons, sometimes I don't, but oftentimes I do have that opportunity, and you can build a rapport that way as well.
Well, I'm sure the approach changes. Let's go back to adults now. When you've got somebody that's an expert witness, right? Somebody who's technically prepared. So how does the approach shift when there's an expert sitting in there?
You want to be as technically competent, or at least sound as technically competent as they are. And so that comes down to preparation. I'll usually have my own expert that's in the same field as the expert that I'm cross-examining. So I will work with my own expert on developing a cross-examination. We'll interview the expert together. We'll review their reports. We'll look at their background, and we'll test their case. But you want to look and sound as competent as they are. You don't want to get up there and fumble around. So that takes preparation.
Well, Joseph, I'm sure there's a difference too between a technical witness and somebody who's like a law enforcement agent, right? Because they've got a different credibility. They know a little bit more of the law. Like, what adjustments do you make then when you're crossing maybe an agent or an investigator?
Law enforcement's interesting. They do feel like they're kind of the cock of the walk, as it were. So oftentimes what I find is that it's getting a little bit better these days, but I would say over the last 15 years, leading into the last couple, I've dealt with a lot of incompetent law enforcement agents and officers on the stand. And so, and they get combative, they get aggressive, they get defensive. And so you want to start off with a certain tone with the panel in your case presentation before you get to that law enforcement agent, so that the jury already knows you, likes you, trusts you. And when they get someone that's on the stand that could be perceived as, for lack of a better term, that gives you permission to go at that agent and go at them hard.
You know, Joseph, one adult that we maybe haven't talked about could be somebody that's like a family member of an alleged victim, because I'm sure there's an emotion that comes with that. How do you kind of balance the line between, you want to apply pressure to the witness, you are the defense counsel, right? But you don't want to appear too heavy-handed in front of the military panel. Like, how do you balance that?
Parents are difficult, very, very difficult. And so, again, you want to approach them with empathy, with emotional intelligence. The easiest way to approach a parent, though, is with cold, hard facts. Keep it factual. Take the emotions out of it. Where there's opportunity to acknowledge their emotion based off the answers that they give you, you do that, but you keep it to the cold, hard facts. The jury appreciates that.
Yeah. Well, let me ask you on that front. So let's say you're keeping it to the cold hard facts, but then you're watching the witness, right? You're watching a little bit of their body language, maybe hesitating on some answers, their cadence. Like, does that tell you anything that maybe you should pivot from your outline? Like, walk us through where you would actually pivot.
So there's a lot of different signals that you see in a case, and after you've done so many, it comes natural to you to pivot. So they may say something that just is completely out of character. So I was cross-examining a Fulbright scholar once, and I asked her a question. I said, unbeknownst to you, the witness said X, Y, and Z. And she looked at me and she said, unbeknownst? And she was like, what does that mean? And that surprised me, but it gave me an opportunity to have some theater with this young lady who was a lieutenant in the Air Force, and a Fulbright scholar. And so I took that opportunity, took my glasses off, I looked at the jury, I looked at her, and I said, aren't you a Fulbright scholar? Yes. You don't know what the word unbeknownst means? No. Means didn't know. And then I moved on, right? So there's opportunities that happen. Sometimes a witness will give you something unexpected. They'll agree with you unexpectedly. You move on. If you've sat there and you've got this whole line of questioning based off of you're expecting the witness to disagree with you, they've agreed with you. You've got your point. Move on, right? And then there's times where they say things that are really contradictory. Like I was cross-examining a witness recently, and she said something, and this was, she was like the main, she wasn't an accuser per se. She was a gate guard. And I had asked her something to the effect of, why did you write the note the way you did, right? So there was a note that was written that was passed off to somebody else, and I wanted to know why you wrote the note the way you wrote it. And she said at first that she couldn't remember the name of the individual she was writing the note about, so it was just, you know, that's why she wrote it the way she did. And I said, well, wait a minute. You just talked to this individual. You knew what his name was. You ran his ID card, and you didn't know who he was? That doesn't make any sense. And then she pivoted again, and she said, well, it was just quicker in the moment. That's the way I did it. I was like, well, which is it then? Is it this one or is it this one? Which one is it? And then she gave me a third reason. So when witnesses do that, you can't just stick to your prepared outline. You don't just stick to your prepared preparation. You have to exploit the natural avenues that they give you. And I mean, sometimes witnesses will do things on the stand. They'll have nonverbals. They'll smile at you. It's a serious cross-examination. Why are you smiling? Is this funny to you? So you just take advantage of it.
Yeah. Well, have you ever found yourself where you walked into cross-examination? We've talked about your preparation on this podcast series. So you obviously are a big planner. You walk in with one plan, you abandon it midstream because the witness, like you just gave in that example, they gave you something really unexpected. Like, can you give us an example from a case? What happened there?
A couple things. So I recently, that wasn't recent, it was about a year and a half ago, I tried a international crimes against children case. It's a To Catch a Predator case up at Fort Drum. And I had a really, really caustic agent on the stand. And I'd already cross-examined him in motions practice. So I already knew this was going to be entertaining once we got to trial. It was a situation where they set up a sting on Fort Drum to, try to catch people who are interested in children. There's a whole series of steps that agents are supposed to go through when they're doing the chats online. And so I'd asked him a series of questions along this line. And I said, hey, you're supposed to be objective, right? You're supposed to have objectivity. And the agent, and this was a 28-year law enforcement professional. He said, well, I don't know what objective is. He said, I don't know what objectivity is. I was like, do you know what it means to be objective? He said, no. And I said, you're the agent of 28 years of experience and you don't know what it means to be objective? He said, no. I said, well, that tracks. I moved on. And so I continued down this line of questioning him, and he really was obstructionist. He didn't want to answer my questions. And it got to the point where I was just like, look, man, are my questions confusing you? Am I speaking a foreign language? Do you speak English? I asked it. I said, do you speak English? Just like that. And he did this thing where he gestured at the prosecution like, help me. And then that was the signal for the prosecution to stand up and object, which was funny because the judge was like, sit down. He could just answer the question. It doesn't pay to play games with an experienced counsel who's questioning you. And that's kind of the point of that, right? So you pivot away from it because you pivot away from your outline, you pivot away from your preparation because they give you the opening to do it. Because for whatever reason, they're protectionist of their case. It's really, really stupid. It's really, really ineffectual. And it turns the jury off. When witnesses do that with defense counsel, we love it. We eat it up.
Right. Well, I was going to say along those lines, like how, maybe not in that example, but like how just in general do you decide when I need to keep going here and give a little bit more of cross-examination, or, you know what, maybe I'll drop out. This guy's already made a fool of himself. I think I got what I needed here. Let me go back and sit down. Like where do you decide that?
It depends. You're looking at what are you trying to accomplish with the witness, right? So maybe he's giving you a golden nugget on your way to the mountain of gold that the dragon is guarding, right? So you've got what I just gave you there was kind of a gold nugget. Sometimes it's a death by 1,000 cuts, and you need to paint the picture for the jury, and this is just one step to paint the picture. And then other times, if you've got what you needed, like I mentioned earlier in this episode, they've agreed with you, hit it and quit it. So you have to know what you're trying to accomplish with the witness. That is most important. If you've accomplished what you're supposed to with the witness, don't continue to cross-examine just to cross-examine.
Right. It's the Costanza, get out on that high note, right? You know, Joseph, let me ask you before we go here, when the cross-examination, like the examples that you've been giving so far, when it is firing on all cylinders and you've gotten what you needed out of it, like what does that feel like in the courtroom? For those of us that are not lawyers, what does it feel like?
It's exhilarating. It is the best feeling to cross-examine a witness and score the hits you want to score and tell the story that you want to tell, because that's what you're doing. You are storytelling through hard questions. You are teaching the jury your case. You're showing all of the fallacies. You're showing all of the falsehoods. You're showing all of the weak points. You're showing all the incredulous situations that make absolutely no sense. You're telling a story, and you're also, hopefully, you're making the panel so upset and irritated with the government that it's a good and quick decision for them to find in your client's favor.
Yeah. It's great stuff as always. Joseph, appreciate the time and the insights as always.
Thank you. Appreciate you, Mike.
And thank you to everyone out there for listening to this installment of Courtroom Quarterback with attorney Joseph Jordan. If you want to learn more, you want to connect with Joseph and learn more about the worldwide court-martial defense practice that he's been doing, do me a favor, visit jordanucmjlaw.com right now. And do me one more favor, as always, hit like, hit subscribe, leave a review, comment, share the episode with someone who needs to hear it. I'm Mike Leon. We'll see everybody next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.